Good afternoon, and thank you for joining us for an MP webinar covering 2023 Employee Handbooks, Designing to Protect Your Company Legally. I'm Katie Kreider, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance, as well as proactive, reliable, deep service, and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I would like to introduce your presenter for today. Unfortunately, Stephanie could not be here today, but I am excited to introduce her colleague, Andrea DeMarco, as your presenter for today. Andrea's practice focuses on representing employers in all aspects of employment law, as well as advising clients on proper compliance with the law to mitigate liability. While litigation is a central component of Andrea's practice, she also advises clients on daily issues related to policies, personal matters, discrimination, harassment, retaliation, leave, wages, accommodations, and compliance. Andrea frequently lectures on employment-related topics, including leave, workplace harassment, wage and hour, employee handbook, and other workplace practices. Hatfield-Schwartz Law Group, LLC, is a woman-owned law firm located in northern New Jersey with a practice centered on labor and employment law. Founded by Stefani Schwartz and Catherine V. Hatfield in 2020, the firm provides dedicated personal attention to each one of their valued clients. Hatfield-Schwartz was created with the mission to focus on client issues and determine innovative solutions with an unparalleled level of quality. They develop proactive business solutions, assisting their clients with all their legal needs. For more information, including how to contact them, please visit their website, www.hatfieldschwartzlaw.com. And just a quick few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out the recording of the webinar later today along with the slides. To ensure that your company is prepared for year end, I'm going to drop a link in the chat for you to book a meeting with an HR professional. And with all of that, I'm going to hand the mic off to Andrea. Andrea, I think you're muted.
Thank you, Katie.
Yep.
Glad I was talking to myself for a minute. Thank you everyone for being here today, and MPHR, thank you for hosting this. So we will be talking about employee handbooks today. So some of the topics we'll be discussing are do's and don'ts, drafting and tips for drafting, the basics, so basic provisions and policies to include in your handbooks, updates, so certain policies and provisions you want to ensure that you are updating regularly and particularly this year, best practices, and then we will wrap it up with a conclusion and any questions you may have. So why maintain an employee handbook? What is the purpose? So an employee handbook provides guidelines for employees to follow, and it advises employees of their rights and responsibilities in the workplace. Handbooks also provide an opportunity to formally welcome new employees and give employees or new employees a structure to follow. Handbooks also provide employers with legal protection. Is a handbook a contract? No, typically no. However, it could be construed as a contract if there is language in the handbook which states that it is a legally binding contract or any other similar language. To avoid that, you want to ensure that your handbook has a disclaimer, particularly in the beginning, which states that this handbook is not a contract and it does not create a contractual relationship. What should the handbook include? So we'll discuss that at length today, but it should generally include policies which create or provide a roadmap for employer and employee obligations and rights. How frequently should your handbooks be revised? So this will depend on your organization and your state. We usually revise our employees or our clients' handbooks each year. Annually, we like to look at them, make sure that there's no updates or any trends that we want to change. You also want to make sure that you're ensuring that any significant changes in the law are reflected. So in certain years, if you know that there's been a significant change in the law, you'll want to ensure that your employee handbook has been reviewed and revised to reflect that change. If there's external factors such as the pandemic, we saw that the pandemic caused a huge impact on employee policies and procedures. So it was necessary to make appropriate changes to handbooks in the past few years. Typically, you want to ensure that you are having your handbook reviewed and revised at least every 2 years to make sure that it is compliant and up to date with the laws if you are not going to have it reviewed annually. Also, a note to make sure and keep in mind is that anytime you change a policy, you want to ensure that that policy is not only updated externally, but you want to make sure that you are updating your handbook so it reflects that change. So some do's and don'ts. What mistakes do you want to avoid making? Don't create a cookie cutter handbook. So what does that mean? You don't want to create a handbook that's just a pro forma handbook. While that handbook might contain some basic policies and procedures that you do want in your handbook and need in your handbook, it's not going to be tailored to your specific organization, and it may not include everything that you really should or need to have included in your handbook. And I'll use an example of I have a friend who's a small business owner, and I've helped him here and there with some legal issues. And recently we were having a discussion, and something he brought up was some HR issues he was having. It led me to a deeper discussion with him and found out that his business does not maintain a handbook. So I told him I could put one together for him, our firm could put it together for him to get back to me, let me know. And a week later, I heard back and he was like, oh, I found one online. Can I just use that? Again, I was like, this may have some basic policies that you can use, but it's not going to be tailored to your organization. It won't contain specific policies that address your issues or that are tailored to your employees. Also, it may not contain up-to-date laws or policies that are compliant with current laws. And it may even contain policies or laws from other states without you knowing. So you don't want to just create a cookie cutter handbook or pull a pro forma handbook. You want to ensure that it is being properly created and tailored to your organization. Don't forget to include disclaimers and acknowledgements. So disclaimers, typically we like to include a disclaimer in the beginning of the handbook, if not at the very end, which states at a minimum that the handbook is not a legally binding contract and does not create a contractual relationship, which states that there is at-will employment as long as you are in an at-will state. And which gives employers discretion to revise the policies in the handbook at any time. Make your handbooks user-friendly. So what does that mean? You want to make sure that your handbooks are easy for your employees to read. So this is something as simple as the format, making sure that it is proper, neat, and organized. You want to have large and legible font, clear margins. You want to use headings so that policies are easy to locate. You want to use a professional and positive tone and language that's consistent with your organization's culture. You want to make sure the handbook itself is organized in an easy manner that's easy to follow. So think about how you'd want to organize it. You want to have it broken up into different sections. So something we suggest is maybe have a section that just covers laws, such as discrimination, harassment, equal employment opportunity laws. Then have a section on employee benefits and paid time off. Have a section on employee conduct, have a section on company property and use of technology, have a section on separation of employment, and so forth and so on. Again, you want to make sure that you're using clear and plain language, so you don't want to put forth legalese or jargon that employees may have difficulty understanding. And have a table of contents so that employees have an overview of all policies that are in the handbook and can easily find and locate a specific policy. You want to understand where to be vague and where to be specific, and we'll touch upon that a little bit more today. You don't want to forget to implement drug and alcohol policies, particularly with recent changes to cannabis law, and we will touch upon that later today as well. And don't assume that all managers and supervisors know your organization's policies, particularly if you are just putting together a handbook for the first time. So this means that just because somebody's in a position of authority doesn't mean that they have read reviewed, and understand the policies, you should ensure that you are sitting down with your managers and supervisors, reviewing the policies with them, making sure that they understand the policies and what their responsibilities are. So don't apply handbook policies inconsistently. Consistently. So what does this mean? You want to make sure that you are applying your policies consistently to all employees. So an example may be if you have a policy that allows employees to take personal time off, and it's a fairly vague policy, which just states that employees have 3 paid days off a year that they can use for personal days, as long as they have supervisor approval. So you want to make sure that if that is your policy, that is applied consistently, that certain employees are not being granted that time off and other employees are being denied that time off, unless there's some sort of supported reason that they're denied that time off, such as it's a blackout period. You want to make sure that you're treating all your employees equally, because if you're not, this could create legal problems for you. Don't forget to update your handbook. As we stated, you want to make sure that you are reviewing your handbook annually or at least every 2 years to ensure that it is compliant with the law. Don't create overly restrictive disciplinary policies, and we will talk about that a little bit further today. And don't forget to keep your attorneys in a loop and ask questions when you are unsure. So if there is a policy that you are unsure about, whether you're unsure that it's compliant, unsure that it is correctly spelled out in the handbook, unsure if it is in accordance with your culture's organization or your organization's culture, you want to make sure that you're checking with your attorney. If there's a certain matter that you don't know how to handle, a personnel matter, again, you want to make sure that you are checking in with your attorney to ensure that you are handling things properly and in compliance with the law. So do put it in writing. So of course, you want to make sure that you have a full and comprehensive employee handbook that is clearly written. Apply it consistently to all employees and ensure that it is distributed to all employees. So this means make sure that you are either distributing it in print or online or by email, whatever works best for your organization. Drafting policies. So some tips. How long should my policies be? There's really no clear answer to this. It depends on your preference, what the policy is, your organization, and what does and does not work for you. As we'll discuss, some policies should be a little more vague, some should be a little bit more specific. So that, of course, will determine how lengthy the policy will be and how lengthy the handbook will be. So vague policies, you want to be vague to maintain discretion to act and to give you as the employer some leeway to handle certain matters. So standards of conduct, discipline, those are policies where you want to be vague so that you know that you have discretion to handle matters on a case-by-case basis, rather than locking yourself in to certain ways of handling things. You want to be specific where you're defining terms or where there is no room for leeway. So a PTO policy or a medical leave policy, you want to make sure that that specifically spells out, this is what the employee is entitled to. These are reasons that they can take leave. This is how much leave they can take, and that there is no room for discretion or leeway there. You want to draft cautiously. So again, you want to make sure that you mean what you say when you are drafting. Proofread your policies, make sure that they are clear. Make sure that they capture what you mean, make sure they are compliant with the law, and you want to be careful of what type of language you're using. So terms like shall, will, may have different impact and different meanings. So you have to be careful with how you're using them. Shall is a must. So if you're saying the employee or the employer shall do X, Y, and Z, that means it is a must, it's required, it's mandatory. If you're using the word may, that is discretionary. You may or may not. So if you want a discretionary policy, such as a discipline policy, you want to use language like the employer may discipline the employee for ABC rather than must, so that you are not locked in to those terms. So some of the basics to include in your handbooks, and this is certainly not an all-inclusive list, and different organizations will want to include different policies and certainly expand upon this, but these are just some basic policies that should be in your handbook. So equal employment, non-discrimination policies, benefits, employee classification, paid time off, leave policies, discipline, separation of employment, confidentiality, code of conduct, at-will statements, and acknowledgement forms. So your non-discrimination policies, you want to make sure that they are compliant with the law. So federal law, Title VI, Title VII covers non-discrimination, and it states that employers are prohibited from discriminating against employees based on their race, color, religion, gender, sexual orientation, or national origin. So you want to have a policy which states that you as an employer will not discriminate against employees on the basis of these protected characteristics. You also want to ensure that you're including any state policies, and your state policies may be more expansive. So in New Jersey, for example, the New Jersey law against discrimination is much more expansive and broad than the federal law. So it provides additional protected characteristics and protected categories. So if you're drafting a policy in New Jersey, you want to ensure that that policy includes those additional protected characteristics. You want to ensure that you're spelling out who's covered by the policy. And again, this will depend on your state laws. So is it employers and employees? Is it volunteers? Is it third parties, customers? You want to make sure that that is spelled out correctly so employees know how to act and who they can act that way with. What aspects of employment does the policy govern? So again, does it pertain just to hiring and termination? Does it pertain to the conditions of the employee's workplace? Typically, non-discrimination laws will pertain to all the above. So you cannot discriminate on the basis of hiring. You cannot discriminate on an employee's terms and conditions. Employment decisions made based upon qualifications. So again, that pertains to their terms and conditions of employment. You cannot make certain decisions of a person's employment based upon their protected characteristics. So you cannot decide that you're going to hire, fire, promote, demote someone based on a protected category. Consequences of violations. So you want to have language in the policy which states that if an employee is found to violate this non-discrimination policy, they will be subject to discipline. We suggest using vague language, so don't say a specific type of discipline, but rather just state that if an employee is in violation of this policy, they will be subject to discipline up to and including termination, and do not spell out anything more than that. Such you as the employer maintain discretion to handle the matter on a case-by-case basis. Benefits, leave, and in paid time off. So you want to make sure that you include policies regarding employee benefits. So health benefits, life insurance, retirement benefits, expense or expense reimbursement, any tuition reimbursement, fringe benefits. And certain benefits do not need to be laid out specifically in the handbook. So health benefits, for example, you don't need to state exactly what the policy is. You can refer employees to check the actual policy, to speak with HR, but you do want to state what benefits employees are entitled to, and you want to state which employees may be entitled to these benefits. So if part-time employees are not entitled to the same benefits that full-time employees are entitled to, you want to make sure that you spell that out so that employees have a clear understanding of what benefits they are entitled to and what benefits they are not entitled to. Paid time off. You want to make sure that your handbooks include comprehensive policies for time off so that employees know what they are and are not entitled to. So family and medical leave, and we'll touch upon that a little bit more. Sick leave, different states have different sick leave laws. So ensure that you are checking with your attorney or ensure that you are checking the law so that you know what you are required and not required to provide to your employees in terms of sick leave. And you want to make sure that that is set forth explicitly in your handbook. So who's entitled to sick leave, what reasons can an employee take sick leave for, and how many days of sick leave can they take, and how is it implemented? So do you provide it in full day increments? Do you provide it in half day increments? Can an employee take an hour of sick leave? You want to make sure that that is all spelled out. So that's the type of policy where you want to be specific. Military leave, and that often falls under leave laws. So FMLA, Federal Medical Leave Law, has provisions for military leave. Certain states have different requirements for military leave. So again, you want to ensure that you're checking with your attorney or reviewing the law to ensure that you know what you are required to provide to your employees under the law, and ensuring that you have a comprehensive policy that spells that out. Voting leave, if you're required to provide voting leave, or if you elect to allow employees to take leave to vote, you want to make sure that that policy is spelled out specifically and what that means. Does that mean that employee can take a full day? Can they take half a day? Are they allowed to come in late or leave early on a voting day? You want to make sure that you are including in these policies which employees are eligible for these leaves. So under certain laws, not all employees will be eligible for every type of leave. You may only have to provide leave, a certain type of leave for employees that have been with the organization for a certain amount of time or that have worked a certain amount of hours. So if that is a requirement, you want to make sure that that is clearly spelled out. You want to make sure that you're including the reasons for leave. So again, going back to sick leave as an example, if you only allow employees to take sick leave for certain designated reasons, namely that they are actually ill, or if it is to take care of a family member that is ill, you want to make sure that that is clearly spelled out in the policy. If you require employees to provide medical documentation in support of any sick or medical leave, you want to make sure that that is clearly spelled out in the policy. And you want to make sure that you spell out employees' responsibilities with taking leave. So any notice that they have to provide. So if they're required to provide their employer with notice or their supervisor with notice by 8:30 a.m., and if that notice has to be in writing, or if a phone call is sufficient, you want to make sure that that is spelled out in your handbook so employees know what their obligations are and so that you can properly enforce those policies. So employee classification, you want to have a policy on employee classifications. This means spelling out full-time versus part-time versus seasonal employees or interns, and making sure that you are defining what that is. So if a full-time employee is an employee who works 35 or more hours a week, make sure that your policy states that. Likewise, if a part-time employee is an employee who works 34 hours or less a week, make sure that your policy states that. This will impact whether this may impact certain benefits or other policies that the employee is entitled or not entitled to. So you want to make sure that each employee understands what designation or classification that they are. It also impacts whether an employee is exempt versus non-exempt. I don't necessarily suggest putting exempt versus non-exempt classifications in an employee handbook because that will not only depend on an employee's full-time or part-time status, but it will depend on the type of position that they entail, and more importantly, the type of position they entail, whether they are exempt or not exempt. And that will usually be a case-by-case basis. So we suggest defining an employee's classification in terms of exempt or non-exempt employee in their employee contract or in the job description rather than a handbook. However, what you can put in the handbook, rather than stating which roles or which job titles are exempt or not exempt, you can define what an exempt employee is and what a non-exempt employee is, so that an employee has a clear understanding of the differences between those two designations. So employee discipline. Typically suggest having a policy on employee discipline which is vague so that you as the employer maintain discretion to determine disciplinary matters on a case-by-case basis and determine the proper discipline on that specific situation. So rather than having a policy which states that an employee will be subject to a written reprimand or a verbal warning if they do A, B, or C, and then an employee will be subject to suspension if they do X, Y, or Z. You don't want to lock yourself into that, because if an employee commits A, but you feel like more severe discipline is warranted based on the circumstances or based on previous behavior, you as the employer want to maintain discretion to be able to make that decision. So you don't want to lock yourself into a scenario or a policy where you have to follow specifically these rules and you can only issue verbal discipline, or you can only issue a written reprimand, or you have to suspend the employee when you don't think suspension is warranted. So while you should clearly set out that you are entitled as the employer to discipline employees, and you should clearly spell out the type of discipline that your organization follows. So if there are steps such as a verbal warning, a written reprimand, suspension, whether that is paid or unpaid suspension, and termination, that should all be in your discipline policy, but you should not say what type of conduct is subject to discipline. Rather, you should just maintain discretion to discipline employees on a case-by-case basis. Separation of employment. So you want to have a section on separation of employment and outline the types of separation or types of termination. So voluntary termination, in other words, firing or terminating an employee. So you want to outline that the employer maintains discretion to terminate employees at any time with or without cause and with or without notice, unless the employee is subject to an employee contract, which states otherwise, or unless there are certain laws in your state which state otherwise. But either way, you want to make sure that you are outlining what rights you have as an employer to terminate employees. So if you are required to give notice under the law, you want to make sure that that is outlined. If you are not required to give notice under the law, but you as an employer choose to be kind and choose to give notice, then you want to make sure that that is outlined. If you want to maintain discretion to terminate employees at any time with or without cause, then you want to make sure that that is outlined in the policy as well. Involuntary termination, so quitting or resigning, you want to make sure that you have a definition of what involuntary termination is and ensure that you have notice provisions. So if you require employees to give 2 weeks notice, you want to make sure that that is outlined in the policy, and also always include language which states something as simple as unless an employee's contract states otherwise, because maybe the employee has a contract which requires them to give 30 days notice, and that contract will supersede the language in the handbook, which states 2 weeks notice. So you want to make sure that you are covering your bases at all points. And again, you might want to put forth ramifications of what happens if an employee does not give proper termination notice. So if you as the employer require 2 weeks and an employee quits the day of, what incentive do they have to give you 2 weeks? You want to create some sort of incentive or ramification. So perhaps you are an employer that allows employees to be paid out for any unused vacation time when they separate from employment. Maybe you want to include language which says that if the employee does not comply with this policy and does not give the proper 2 weeks notice, they will not be paid out for their vacation time upon separation of employment. Final pay, you want to make sure that you have language in there which addresses how employees will receive their final paycheck and ensure that that is in accordance with the law. Typically, you are required to issue an employee's final paycheck during the next pay period. So that may be within 2 weeks for most employers. Health insurance, you want to state what happens to an employee's health insurance when they separate from employment. Under the law, typically you have to maintain an employee's health insurance until the end of that month. So you want to clearly spell that out, and you also want to make sure that you have language in there regarding COBRA so that an employee can elect to utilize COBRA and that the employer will provide the employee with proper documentation to do so if the employee elects to participate in COBRA. Return of property, you want to make sure that you have language in the policy which states that upon the employee's last day of employment, they will be required to return all company property, including but not limited to, and that may include computers, keys, documents, etc., anything that the employee may have in their possession that belongs to the employer. You also may want to have language in there which states that the employee agrees to destroy any confidential documents or return any confidential documents. You also may want to include language in there that states that after the last day of an employee's employment or the effective last day of their employment, they are no longer permitted to access employee email accounts and employee accounts, particularly electronic accounts that they can sign into from anywhere. I think this is really important to include in your handbooks and even in your contracts. We see this happen all the time where an employee leaves and the tech department is a little bit slow or lapsed on turning off the employee's email account and their electronic logins. And months later, the employee still has access to their accounts, and it can become a problem because the employee still has access to confidential employer information, to client information, to employee information, customer information. So you want to make sure that you have language in there which states that the employee is not permitted to access the accounts in the event that it takes some time for the employer to actually turn those accounts off. You also want to make sure that you are addressing in your separation of employment section how any leave, accrued leave, is handled when an employee separates from employment. So if an employee is entitled to sick leave, to vacation leave, to other paid time off, and that time has accrued and the employee has a bank of leave time when they are separating from employment, you want to make sure that there's proper language in there which states what the employee is or is not entitled to. So the employee is entitled to X amount of accrued but unused sick days, or the employee is not entitled to any accrued but unused sick, vacation, paid time off days, just so the employee understands clearly what they are and are not entitled to, and so that the employer is not obligated to pay something that they should not otherwise be paying. So at-will employment, assuming that your state is an at-will state, you absolutely want to make sure and maintain that you have an at-will statement in your handbook. So something as simple as the employee understands and acknowledges that they are an at-will employee and that the employer can terminate their employment at any time with or without cause. So generally what at-will means is that employers and employees are free to terminate their employment at any time. However, you want to make sure that you as the employer maintain that discretion. So as long as you are an at-will state, you want to ensure that that language is clearly spelled out in the handbook so that an employee can never come back and challenge you and state to you as the employer that you were required to give them notice, or that you were required to only terminate them for cause. You want to ensure that you maintain the discretion and the ability to terminate an employee for cause or without cause, and with notice or without notice, as long as it is compliant with your state laws. However, a caveat that you want to make sure that you include, again, is that unless the employee has a contract which states otherwise. So if the employee has a contract with the employer that states that the employer is required to give them 2 weeks notice, then that supersedes the at-will ability to terminate them at any time. But that aside, you still want to make sure that you just have a broad statement in the handbook that states that employees are at will and the employer maintains discretion and authority to terminate employees at any time with or without cause unless they are subject to an employee contract which states otherwise. So policies to update in 2023. So we have seen a lot of changes to family and medical leave policies, not so much on a federal level. Their FFRCA went into place 2 years ago, but it is no longer in place. So no longer needs to be an employee handbook. So on that note, if your handbook does state language pertaining to the FFRCA that was put into place during the pandemic, you want to make sure that you remove that because it is no longer a law that's in place and employees are no longer required to comply with it. You want to make sure that you're checking your state medical and family leave laws. Lots of family and medical leave laws changed during the pandemic. Some of those changes were temporary. So if they were temporary changes and those changes were put into your handbook and those laws now expired, you want to make sure that you are removing those laws. If they were not temporary, if they were permanent changes to the laws, you want to make sure that your handbooks include those updated changes, set forth what the effective date is of those changes, and ensure that your employees are aware of those changes. COVID-19 policies, you want to make sure that you're regularly updating your handbooks and your policies to reflect the current state of the pandemic. So we saw lots of changes with testing, vaccine requirements, vaccine encouragement, masking, social distancing, cleaning, enhanced cleaning, all those policies that relate to COVID-19. You want to make sure that you are revising them as necessary and updating your policies as necessary. Hybrid remote work policies. As we know, the pandemic has changed the world that we live in, and many employers now have a hybrid work environment and some have gone fully remote. So if you have a hybrid environment, or if you have a remote environment, or if you allow certain employees to be remote, whether part-time or full-time, you want to ensure that you have policies that reflect that. And we're going to touch upon that a little bit more. So workplace harassment policies, harassment and discrimination, utmost important. Always seeing employees bring lawsuits based on harassment and discrimination. So you want to ensure that your policies are comprehensive and up to date with the law. So that means not only ensuring that the law is spelled out and the employer's requirements are spelled out, but that there is a reporting procedure in place under those workplace harassment and discrimination policies that allows employees to report any incidents of workplace harassment or discrimination and sets forth that the employer will address those reports adequately and in a timely manner. So whether that is investigating and disciplining where necessary. You want to make sure that that is all spelled out in your handbook so that employees know their rights and their obligations. And it will also provide you as the employer with legal protection. As an employee or employment lawyer, I handle harassment and discrimination litigation consistently all the time. And one of the first things the opposing side will ask for is whether the employer maintains a harassment policy or discrimination policy and a reporting policy under those harassment and discrimination policies. So you want to ensure that you have comprehensive policies in place that will provide you with protection. You want to ensure that those policies are updated regularly as the laws are constantly changing, and that is not a policy that you want to be out of date. Drug and alcohol policies and equal pay policies, which we will touch upon. So family and medical leave policies, we've discussed this a little bit already today, so I won't go into too much detail. But again, you just want to ensure that these policies are compliant with the law, ensure that employees are aware of the interaction between state and federal leave laws. So for example, in New Jersey maintains the New Jersey Family Leave Act, which some of the reasons that an employee can take leave under the New Jersey Family Leave Act are the same reasons that an employee can take leave under the Family and Medical Leave Act, which is the federal act. So if an employee is taking leave for a reason that falls under both the state law and the federal law, that leave time will run concurrently, meaning that an employee cannot have consecutive leave time. So you want to ensure that that is clearly spelled out in the handbook, if that is the case in your state. You want to ensure that your handbooks not only set forth what the federal Family Medical Leave Act provides, but any counterpart to that under your state law. So again, and we touched upon this, but for FMLA, I'll use that as an example since it is a federal law and everybody is required to comply with it. You want to make sure that the law is spelled out in a policy. So stating who's required to comply with this law. So as an employer, if you have 50 or more employees in a 75-mile radius, you are required to comply with the law, and it should be in your handbook. What employees are eligible, that should be set forth clearly in the handbook. So under FMLA, only employees that have been employed with the employer for 12 months and that have worked at least 1,250 hours in the past 12 months are eligible for FMLA leave. You want to make sure that that is clearly spelled out, because if an employee does not have that background, and if an employee is not eligible, they will not be entitled to leave, and you want to ensure that the employee knows that. It's set forth in the policy. This way they are not challenging you as the employer. You want to ensure that the reasons that an employee can take leave under the FMLA are clearly spelled out so that an employee knows what reasons they can or cannot seek leave under FMLA. You want to make sure that there's any notice provisions in there. So when an employee is required to give 30 days notice unless it is emergent, meaning that they have to tell the employer at least 30 days prior to the date that they are planning to take leave. Under FMLA, employers are absolutely entitled to seek medical certification from an employee in support of the leave that they are taking. So you want to make sure that that is spelled out in the handbook so that employees understand that they may be required to furnish medical documentation. And you want to put any other nuances in there. So how much leave can an employee take under FMLA? It's 12 weeks of leave max in a 12-month period. Employees can take consecutive leave or intermittent leave. You want to make sure that that is spelled out in the policies. Again, you want to make sure that this is a specific policy and that each part of the law is spelled out so that employees know what their rights and obligations are, and so that the employee also has a roadmap to follow. You want to do the same thing for any state paid leave laws. So again, if your state maintains family or medical leave laws, ensure that that is spelled out, including who's eligible, how much leave they're entitled to, what reasons they can take leave for, any notice provisions, any medical documentation that may be provided, and what may happen to their health benefits during the period of time that they are on leave. And again, as we discussed, you want to make sure that you clearly set forth any interaction between state and federal leave laws. You also want to ensure that you're setting forth what occurs to an employee's pay during the time that they are on leave. This is something that is of constant confusion for employees and can be a challenge to employers and create contention. So you want to ensure that employees understand that these are unpaid leave policies, at least the Federal Medical Leave Act is. I believe most state medical and family leave policies are also unpaid, but of course you need to check with your state law. So you want to make sure that you are clearly spelling out that during the time that the employee is taking FMLA leave or similar state leave, that they are not entitled to pay from the employer during this time. However, they may be entitled to seek supplemental benefits through the state or whatever laws your state may have in place. Sick leave policies we discussed. Americans with Disabilities Act, so this could potentially be another leave law. You want to ensure that the Americans with Disabilities Act is set forth in your handbook, meaning that you are clearly setting forth what the ADA is, what you as the employer's obligations are under the ADA, and what the employee's obligations are under the ADA. So this does not need to be a really detailed and comprehensive policy, but can be just a simple paragraph that says, under the ADA, you will not discriminate against your employees on the basis of a disability. You are required to provide a reasonable accommodation as long as that accommodation will allow the employee to continue to perform the essential functions of their job. And if employee is seeking an accommodation or leave under the ADA, they should request that leave with HR or whomever the appropriate person is in your organization. You want to make sure that you are addressing any other unpaid leave. So in addition to any family and medical leave policies that are required under the law, in addition to sick leave, in addition to the ADA, are there any other unpaid or paid leave policies? So jury duty, bereavement leave, voting leave, and even other unpaid leaves of absences. Some employers will allow their employees to take additional unpaid leave for reasons that may not fall under the Family and Medical Leave Act or other state laws. So if you are going to offer that to your employees, that's great. Just make sure that it's clearly spelled out in the handbook. So again, what type of leave will they be allowed to take? How much leave can they take? Will it be paid or unpaid? And what happens to their benefits while they are on leave? So COVID-19 policies, we touched upon this a little bit. You want to make sure that you are removing any policies that are no longer in effect. So any mandates, policies about masking, policies about testing, enhanced cleaning, and other infection control measures. If your organization is no longer following these policies, make sure that they are removed from the handbook. Vaccine policies and communicable disease policies. We recommend leaving communicable disease policies in place because it will still provide guidelines and protection for how that should be handled by your organization. So again, this could be screening, not reporting to work if you are sick, enhanced cleaning, hand washing, and just other infection control measures. Hybrid or remote policies. If your organization allows employees to work remotely, whether on a full-time or hybrid schedule, you want to ensure that you are creating and including policies in your handbook which address this. So the clear parameters and expectations of employees that are working remotely. So making sure that employees understand that they are still required to be available between hours of 9 to 6 or whatever hours your organization is open. Making sure that employees understand that any workplace policies and procedures will continue to be enforced even if the employee is working remotely. If a policy is created or changed, making sure that the employee has a copy of that policy and is on notice, because if that employee is not in the workplace, you want to make sure that they are still up to date and still receiving any of the same notices that any employees that are actually in person in the office are receiving. Confidentiality and security, it is utmost important to make sure that any employee who's working remotely is maintaining confidentiality of any workplace documents and is maintaining security. So meaning that if they're logging onto the internet and logging onto your software system, logging onto their email, opening employee documents, employer documents, client documents, you want to maintain that they are in a secure place. So if they are at home, ensuring that their computer and their files are somewhere where third parties cannot see or access it. They probably should not be working remotely from a Starbucks or somewhere where there's going to be a shared internet and where security can easily be breached, or where third parties can be walking by and easily see their documents or their computer screens. The remote work option or policies at the discretion of the employer and can be changed at any time. So unless you are a fully remote organization that has no intention of ever returning to in-person, you want to ensure that you have policies in place that state that while right now you may have a hybrid policy, or why right now certain positions are allowed to be remote, whether on a full-time or part-time basis, You as the employer maintain discretion to change that at any time for an entire group of employees or even a specific employee if that employee is not getting their work done or is not following workplace policies while they are working remotely. So if employees are allowed to work remotely 3 days a week, but you find that the productivity is suffering greatly while they're working remotely 3 days a week, you maintain discretion to change that policy and only allow employees to work 1 or 2 days a week or not at all. But you want to ensure that that is in your policies, that you as the employer at all times maintain discretion to be able to change those procedures at any time. In the absence of a hybrid remote work policy, keep in mind request to work remotely and reasonable accommodation. So if you are not an organization that generally allows hybrid or remote work, you just want to keep in mind any requests for remote work and reasonable accommodations that may need to be provided. So if you have an employee that is requesting to work remotely because of their personal circumstances or because of a medical reason, that is something that you may need to address under the law and make sure that you are handling it properly. So we talked a lot about workplace harassment policies. And again, you need to make sure that they are compliant with your laws, your state law, ensure that they are addressing both harassment and sexual harassment, bullying, and other types of offensive conduct in the workplace. Make sure that they have reporting procedures. As we stated, you want to ensure that you have a proper reporting procedure in place so employees know that they can report to this supervisor or to HR and that those reports will be taken seriously and will be handled in a timely manner. You want to make sure that you have a statement in your workplace harassment policies and discrimination policies, which states that no employee will be retaliated against for making any good faith report of harassment, bullying, sexual harassment, or discrimination. You want to have a confidentiality statement in there that states that if the employer is investigating the matter, confidentiality will be maintained to the fullest extent possible because, of course, full confidentiality cannot be maintained. And there might be training, harassment or discrimination training that is required in certain states for certain or all employees. So you want to make sure that you understand what your state laws are. And if training is required, make sure that you are implementing those training policies for your employees. I think I'm getting close on time here, so I'm going to try to speed up. So alcohol and drug policies, you want to make sure that you have a policy in place that addresses that you are maintaining a drug-free workplace and addresses alcohol and drugs in the workplace. So your policy should state that employers maintain a drug-free workplace. There should be language which states that being under the influence of alcohol, illegal drugs, or recreational marijuana during working hours is not permissible. What we are seeing now is the cannabis laws are changing and evolving is how do we handle recreational marijuana that may not be legal in certain states and how do we handle medical marijuana. So you want to check with your state laws. You can say, for example, in New Jersey, medical marijuana is legal. However, employers are not necessarily required to accommodate the use of medical marijuana in the workplace. So if that is the case in your state, you might not have language in your handbook that states that employers are not required to accommodate the use of medical marijuana if it impairs an employee's ability to perform their job function safely and effectively. So that means that while you cannot discriminate against an employee for being a user of medical marijuana, if it is impairing the employee's ability to perform the essential functions of their job in the workplace or to perform safely, you do not have to accommodate them and you absolutely can discipline or terminate that employee. So drug testing, you may want to have a policy which addresses drug testing. Again, this will vary state by state as to what's permissible, the reasons you're permitted to test, the process for testing, and any adverse action that you may or may not take against an employee. Cannabis laws as to recreational marijuana, just because a state has approved the use of marijuana for recreational uses or made it legal does not mean that employees can be under the influence of marijuana in the workplace. It should be treated the same as alcohol. So equal pay policies, the Equal Pay Act just says that men and women in the workplace must be given equal pay for equal work. And while the job does not need to be identical, they must be substantially equal. So having a simple policy, which just simply states that the employer complies with all equal pay laws, and will ensure that employees are paid equally and fairly is simple enough. You don't need to be too detailed. And again, you just want to make sure there's a no retaliation provision in there. So stating that if an employee feels that there is a violation of an equal pay law or equal pay policy, that they can report, and as long as they are reporting in good faith, they will not be retaliated against. So to some best practices that we have discussed today and that you should use moving forward is making sure that you are tailoring your handbook to your company and your company's needs. So the size of your company, your type of company, the type of business you do, the type of customers you work with, and your employees. Applying policies consistently to all employees, revising your handbooks regularly, distributing your handbooks to all employees, and making sure that your employees have easy and equal access to the handbook, including broad disciplinary policies, making sure that you have disclaimers, and making sure that you have acknowledgement forms. And I don't know if we touched acknowledgement, so I'm just going to quickly say, you want to ensure that there's an acknowledgement form at the end or the beginning of your handbook, which states that the employee will sign the acknowledgement form, and the acknowledgement form will easily state that the employee read the handbook, they understood the terms of the handbook, and they have agreed to comply with all terms in the handbook. You want to make sure that you are keeping that acknowledgement form on file in the employee's personnel file. That will help provide you with protection in the event that there is a lawsuit or a challenge to one of the policies in your handbook. Okay, I know we only have a few minutes left, so I will look if there's any questions, and if not, you are all free to email over questions, and I'm happy to answer them at a later time. Okay, one question is, what do you do if an employee refuses to sign an acknowledgement form? Well, first, employees are required to comply with the company's policies, so it should be explained to the employee that even if they do not sign the acknowledgement form, they are still required to comply with all company's policies and procedures and the terms of the handbook. Second, you want to make sure that you are documenting this or memorializing this. So either have the employee write on the acknowledgement form that they refuse to sign, or you should document it yourself, put a memo in the employee's personnel file, and perhaps follow up with the employee by letter or with an email that states that on X date, the employee advised so-and-so that they refused to sign the acknowledgement form for the 2022 handbook. Is there a legal requirement to create or maintain a handbook? No, there's no legal requirement, no federal legal requirement. As far as I know, there's no state requirements, but you want to make sure that you have a handbook for all the reasons that we discussed today. So handbooks provide guidance and information for employees, and it helps protect employers against liability. Okay, I'm going to hand this back over to MPHR. If there's additional questions, feel free to keep asking them. I will review them as we are signing off, and I can follow up individually or speak with MPHR about following up individually. Thank you all for your time today.
Awesome. Thank you so much, Andrea. To learn more about MP's HR services for 2023 and more, I'm going to drop a link into the chat here in a second. You can also visit our website or call 774-266-6497 to learn more information. Be sure to join us next week on our upcoming webinar covering quiet quitting, what employers need to know. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out the recording of today's webinar along with the presentation slides this afternoon. Thanks so much for joining us and have a terrific day.